Alex here with a video on legal nuts and bolts. The topic is going to be motions. Now, even though this is a legal nuts and bolts video, I will be using examples from my child custody case just because I probably filed more motions in my child custody case than all my other cases combined. So I'll just go straight into it. A motion is your way of formally asking the court to do something. That's the most simple explanation I can give you. When you're in court, a lot of people think you just get a hearing and you just go and tell the judge verbally what you want. But this is something that I've mentioned only really applies to small claims cases. And it's really confusing to people, especially if they've only seen like Judge Judy on TV. It might look like that's just how court works. But in reality, at least in Nevada, high conflict child custody cases, or any child custody case, divorce cases, annulments, petitions for termination of parental rights and adoption, all of these cases are formal lawsuits, and they go into the judicial district court of whatever county you live in, and it is nothing like what you see on TV. Part of the problem is there are various different types of hearings, and some people can't even tell which one is the trial unless you're paying close attention and you're learning the procedure. You're not going to know, why you're in a hearing. It'll have a name. It'll be called a case management conference, and you'll be there, and the judge will be there, and you'll think, oh, this is the person I can ask for things, and then they'll just cut you off and say, wait, whoa, this isn't the right time. We're not, at a hearing on that. We're just here to discuss this. And so it can be very confusing for people. So motions is how you formally ask the court to do a specific thing. And hearings can come from you having filed a motion. And at those hearings is where you can discuss the issues that you raised in your motion and actually get a ruling on the issues that you raised. Now, in a normal child custody case or any other court case, after the complaint is filed or the petition is filed, you're going to go through this process of, as I mentioned, case management conference, possibly a settlement conference, possibly some kind of pretrial conference. And then at the end, you're going to have a trial. And that's going to be on all of the issues brought up in the petition, and that's going to resolve the whole case. Well, there are situations where you can bring up issues before that trial comes up with a motion. You could ask the court to dismiss a case before you even get to the trial. You can ask the court for a summary judgment because there's no need for a trial. There's only legal issues for the court to resolve. There's different techniques you can use to resolve a case before. In child custody cases, most of this stuff is filed after your trial's already over, or after you settle your case, in which case you've waived your right to a trial because you settled it. You agree to a certain stipulated order or judgment or whatever, and that's it. There's no trial. When you agree, it's done. Anyway, after either that has happened or after you actually got a trial, a lot of times in child custody cases, people have issues that are happening and they need to go back to court, and the way that happens is by filing a motion. You don't just call the court and ring up the clerk and say, hey, can I get a hearing next month, and they just set a hearing and you just go in there and talk. It doesn't work that way, at least not in Nevada. I'm not sure it works that way anywhere. You have to type up a big old motion. Usually it's long. It's not always long. Bringing up all the issues that you feel need to be addressed. By the way, this is called a post-judgment motion. In the way I'm referring to it, because the case is already over, whether by trial or by settlement. And so what you're trying to do is get post-judgment relief. You're trying to get a ruling from the court after the case is closed. Most of the stuff in child custody cases happens post-judgment. It's just the nature of the beast. People don't always move on from their child custody case. One person will have custody, and then later on the other person will want it. Or somebody will want to change visitation, somebody will want to do something with child support. Anyway, that's how all this stuff happens. It starts with a motion. As I mentioned in some of those examples, if you want to change your child support order, you have to file a motion. If you want to try and change the way custody is outlined, you have to file a motion. So that's where I'm going right now, is I'm trying to explain to people what it is. So there's forms that you can get. Before I even start, I'm going to go into the forms. In some states, for example, California, and I believe maybe Colorado, the forms will look like an application, like for a loan or for a job or something. If the form looks like that, I don't suggest following the advice in this video, which is to learn how to customize your motions and your other papers and pleadings. if your forms look like those applications, as I mentioned, an application for a job or a blank loan or something, if it looks like that, you should probably just use those forms. I'm not sure how receptive the court is going to be to you customizing your own forms. It might turn the judge against you, especially if lawyers end up using those forms too, which I have a suspicion that they do. I'm not sure if they get to attach things to the back of them. You can look into that yourself. If it looks like you can attach points and authorities or something like that, go ahead and continue to watch this video. But otherwise, I'm not sure that this is going to be much use to you. If you have the forms like we have in Nevada that actually look just like a court paper, but it's got blanks all over the place and you have to fill in those blanks, then I would still suggest you watch this video and learn how to make your own forms. In that case, the forms already look like court papers anyway, and they just look kind of hokey. You might want to use those for, maybe your first or second motion. I did use the forms a little bit and I transitioned out of them because I just got taken more seriously later on when I started to type up my own stuff rather than use those forms. So anyway, by the way, those forms could give you a lot of insight as to how your forms should look. As far as the formatting, the font you should be using, the size of the font, the numbers on the left-hand side of the page. You can use those forms because they look like court papers anyway to sort of guide you on the template that you need to have your custom court papers on. So the first thing about a motion is you're going to have facts. You're going to assert like a factual background, and then you're going to have a second part for legal analysis. Your factual background is going to be all of the facts that are happening that will support the legal analysis, which is basically what you're asking the court to do and the law that supports what you're asking the court to do. It's a good idea to put these into two separate categories. The only time I've ever blundered them together or bundled them together, the factual background and the legal analysis, is when I had like a 2-page motion, when it was super short. In all other cases, in most cases, I had my factual background in the first half of the motion and my legal analysis in the second half. So as I mentioned, say for example you're modifying child support, your factual background is going to contain things like my wage, I used to work here, my salary used to be this. On this day I got fired, or my hours were reduced, or something like that. I got a new job, or I'm unemployed, something like that. My new job pays me this much, and I only work this many hours. Or I've been unemployed for 6 months and I've been trying to get jobs. Anyway, the point is you're going to put the facts that support what you're asking for in the motion in the factual background. I like to put it first, so I put it in the top. So it ends up starting on page 1 or 2. Then you're going to put your legal analysis. And that's going to be what you're asking the court to do and the law that supports why the court can give you what you're asking. So for example, if you're modifying child support, you're going to cite the statutes. If you're in Nevada, you would cite the statutes that state after 3 years I'm entitled to, pursuant to this statute, after 3 years I'm entitled to a modification of child support. My last court order on child support was entered 4 years ago. That's basically good enough. You cited the statute, you explained that your last court order was 4 years ago, and of course if you reference that in your factual background, you have the fact that supports what you're asserting. Maybe it hasn't been 4 years, maybe it's only been 1 year, but your income has changed by like 40%. Well, in that same statute, there's a subsection that says that you're entitled to modification of child support if your income has changed by, I don't know, 25%, 20%, I already forgot. The point is, the second half of your motion has those statutes and what you're asking the court to do, and of course the facts that support what you're asking the court. So in that other case, it would be, you'd be referring to the fact that you lost your job, or that your job changed, or that you are working less hours. Some people really cut corners on the legal analysis, and they won't actually cite any statutes, and they'll just say, I'm poor, please modify my child support, or something like that. You're playing with fire when you do that. Luckily, child support is a really mainstream issue, and so the judge will probably just pick up the slack for you, but you're really playing with fire, because if something happens and the judge isn't nice, which I've mentioned in previous videos, try not to rely on the judge being nice, because it's like like I said, it's like throwing dice and getting lucky. Because sometimes they're not nice. Sometimes they're busy. Sometimes they are nice, but they're busy and they don't have time and they make a mistake. And now they've made a mistake and you haven't cited the law that supports what you're asking for. Guess what? Now you can't appeal it. Simple as that. The Supreme Court's going to reject it because they're going to say that you didn't cite any relevant authority. You just asked for something without citing authority. That's what they consider rules, statutes, and case laws is authority. Anyway, they also call that the, jumping a little bit off topic, but the factual background and the legal analysis combined, those two parts are known as the Memorandum of Points and Authorities. Every motion has to have those. I kind of just glazed over that and went straight into those, but just so you know, if you've ever seen that phrase before, if you've ever seen Memorandum of Points and Authorities or anything like that, that's what that is. It's your facts, your request to the court, and the legal basis for what you're asking for. That's the Memorandum of Points and Authorities. If you don't actually type that in your motion, it's fine. It's not going to be rejected for that, but a lot of times I'll typically start it off at the very top as motion for blah, 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 blah. And then I'll put in, comes now, Alexander Falcone. And then and then right after that, I'll put Memorandum of Points and Authorities. And then right after that, I'll start my factual background and go into that. And then after that, I'll go into my legal analysis and go into that. It might sound intimidating, but after you do it 2 or 3 times, it's like writing a letter, except you have to do a whole lot of homework before you mail it. So maybe I'll find an example and post a link to it or something. Actually, I'm not going to do that, because if you Google like sample motion, you should find tons of examples on your own. Especially if you Google like sample motion and then put your state's name, you'll probably find some specific to your state, just so you can get an idea of what they look like. At the very bottom of the motion, you can include something called a certificate of service. Some people file it as an extra thing, as a separate thing, and a separate piece of paper. It just saves paper. And a lot of lawyers do this too, as you just attach your certificate of service to the very bottom of your motion. And it's going to just contain the language that says, I, such and such, hereby swear under penalty of perjury that I mailed this to such and such at this address. You'll find samples of those online. You'll be able to also steal the language out of any court forms you can find. So if you don't know what it's supposed to look like, get some other court forms from your state and look for a certificate of service, and then just copy that language and put it at the bottom of your motion. You could also look into the court rules and such. It's a little bit trickier, especially if you've never done it before. I started out by just taking the certificate of service just from the forms from the Nevada Self-Help Center. So that's why I kind of suggested that. You can't really go wrong with those, since those are actually official forms from the courthouse. It's not as risky as if you just find some random form online that some private person or attorney has wrote. So I'm not sure that I would recommend you steal a language from those. But if you're going to go ahead and take it from anything, take it from the self-help forms. Just so you understand, what the certificate of service is basically satisfying the obligation that you have to let your opponent know that you filed something with the court. In Nevada, a judge won't even consider your motion if you didn't serve it. And if you did serve it, but you didn't put a certificate of service and sign it, they're going to have no idea that you served it. They're going to think this person didn't serve this motion, or they have to at least assume it. And your motion will get denied, or it won't even be considered. It'll just sit there. So make sure you look into that. I can't think of any example where you don't have to serve your opponent, with the exception of ex parte motions, which I've covered in a previous video, ex parte perils. If you really want to know what those are, you can check out that video. There is some situations where you actually don't have to attach a certificate of service, because the court will automatically do it for you. I think the federal courts do this. I know that lawyers in Clark County, which is the Las Vegas area, they'll have to subscribe to electronic service. So when they file motions down here in the Clark County courthouse, they don't have to attach a certificate of service, because it just gets mailed. Or sorry, not email. It gets electronically served, which is email, and so that takes care of it for them. Look into whether or not you have to put any affirmations at the bottom of your motion. In Nevada, we have to put this NRS 239B affirmation, which states that the court paper that you're filing doesn't contain the social security number of any person. I'm not sure that this is a thing anywhere else, but just in case, check it out. Make sure that your state doesn't require you to put anything like that. Usually you'll see it in the self-help forms. If there's any kind of weird, quirky requirements like that, you'll usually see it in your self-help form. And you'll be able to take the language of that and put it into your custom motion. At the very least, the clerk will reject it and tell you why. They'll say, we can't file this unless you put an affirmation on it. Or they'll give you a separate form with like the word affirmation, and they'll have you sign that, and then they'll take it from you. Also, in Nevada, at least, according to the court rules, again, please check the court rules because your state might have something that I've never seen before. Anyway, in Nevada, the court rules require your motions to be supported by affidavit. Please watch my video on affidavits to know how to get them and when they're useful. And I mean, there's a lot that I go into on affidavits. But at the very least, if you don't have anyone who's going to provide an affidavit to support your motion, at the very least, support it with your own affidavit, which is at least, basically, it's you swearing that everything in there is true under penalty of perjury. I've seen it happen sometimes where a judge in Nevada will find a motion without an affidavit and they'll reject it. And the reason is that they want to be able to hold your feet to the fire if you're lying. And at the very least, it needs to have an affidavit just from you. So now sometimes, and a lot of times I used to do this, if it's not really a complicated issue, like if it's modifying child support, I'll just have this some generic one-paragraph affidavit literally inside of the motion, like right before the certificate of service, that says something like, I, Alexander Falcone, swear that I've read this motion, that everything in it is true, and to the best of my knowledge, and all that, yada, yada, yada. It's a really like cheesy, just generic affidavit, but for simple things like maybe modifying child support, it really doesn't have to be that detailed. For other things, like for a motion for order to show cause to hold your ex in contempt, I don't recommend doing that. I recommend having a separate affidavit from you that is highly detailed. So, you know, you really have to figure out what's appropriate. And of course, if you can get affidavits from other people, like when, for example, when I did my motion to modify legal custody, for me to get sole legal custody, I alleged that it was time for my son to have an eye appointment. I got an affidavit from the optometrist. If you can get affidavits from other people, especially professionals, then that is pure gold. Go ahead and do that, and definitely rely on that in your motion. It just looks very strong. It looks very convincing. It doesn't look like you're coming back to harass your ex if you went to the effort to get an affidavit from your optometrist. So again, I mean, of course, if you can't do that, or if it's a really low-key issue like modifying child support, you don't have to go that all out. You can just have your own affidavit in there. But if you're asking for a lot, you're trying to modify physical or legal custody, then that's the time to gather a lot more than just your own affidavit and rely on that in your motion. So with that, I'm going to cover, oh, one extra thing. In Nevada, we have this annoying thing called a family court motion opposition notice. If you don't provide that with your motion, it basically has you fill in some boxes and check mark things and figure out if you have to pay a fee. If you don't include that with your motion, you'll end up getting, it'll get rejected. So check in your own state. Sometimes a family division will require some extra kind of form to be filled out. As I mentioned, for Nevada, it's for the purpose of figuring out whether you have to pay an extra fee or not. I'm not sure if your state's going to have that, or for what the purpose will be. Here's another thing. Sorry. So sometimes you have to put some kind of boilerplate language at the very top of your motion. For example, in Clark County, you have to put in this really long paragraph that lets your opponent know that they have a certain amount of time to oppose the motion, and if they don't file something in that amount of time, you might just win without a hearing. So check into, again, as I always say, check into your court rules, or you could look at your self-help center forms, and again, it'll be a dead giveaway if it's in your self-help center form that it's probably some kind of rule in your location that you have to provide some kind of boilerplate language at the top of your motion. Again, over here, it's just Clark County. So in Washoe County, where my child custody case was, I didn't have to do that. So it's just like I mentioned, Even sometimes it can go down to the county you're in. Whether the rules are the same aren't always consistent even across the state. You know, sometimes a specific county can have its own specific set of rules. You have to look into these things. It's really frustrating because a lot of people are like, "Oh, I just want to get, you know, the best for my kid and I have to do all this homework." But you have to realize that this machine is churning out thousands and thousands of decisions per year. If things aren't organized to the way they expect it, it causes all kinds of havoc. And even though it's unfair that the rules are so different all over the place, in that locale, they feel that the rules they have are best for their locale. So, I mean, you can go in there and you can just throw a hissy fit about their rules being so different from all the other counties, but they're just going to get frustrated with you because they're just going to be like, well, the least you could have done is at least read them and followed them. And it's just really, both sides are frustrated. The court's frustrated because it's overburdened and it has so much paper to churn through. And then the self-represented people are so frustrated because the rules seem so pointless to them. And it's just, you just have to read them. I've already come up with so many examples where different things apply in different places. You just have to read them. In the, there was another, I think there was one more thing I wanted to mention with regards to motions. But now, sometimes they have a code. So yeah, you have to sometimes motions will have a code that you have to put in the upper left-hand corner. We had this in we had this in Washoe County, and they had this like big chart, and you had to go look in the chart and find out the code that matched what you were doing. So like if it was an affidavit, it was this number. If it was a request for submission, it was this number, and you'd have to put that code in the upper left. It's another thing to look into just in case that applies to what you're trying to do. Sometimes you have to pay a filing fee. I mentioned in Nevada we have that family opposition notice, and of course, and I mentioned that you the purpose of filling that out is to figure out if you have to pay a fee. So that kind of ties into this. You might end up going to court to file something, and there's a fee you have to pay. It's usually it's not a lot because your court case is already open. You're just filing a motion, so sometimes it can be like $25. Other times you don't have to pay any kind of fee. Oh, you have to kind of figure out the pattern of how to go about getting things file stamped. So when you finish your form, or sorry, when you finish your motion and you sign it at the very bottom or wherever you have to sign, you'll often want to get a copy for yourself. So just make sure that when you wrap your form up, or your motion, sorry, that you figure out how many copies you're going to need. So like if you don't really want a copy for yourself, then you're probably only going to need one other copy because that's the one that you're going to serve on your opponent. So one original and one copy. If you do want a copy for yourself, then you're going to need 2 copies and 1 original because the court's going to keep your original. One of those copies you're going to keep at home, and then the other copy you're going to mail to your opponent. In weird cases, you may have sued like 3 different people. If it's not child custody, this could happen, and you may need to print 4 or 5 copies. Anyway, you go to the court with your original and copies, and they'll stamp them all, and they'll keep the original, and they'll file it in their system, and they'll hand back to you the copies, which will have file stamps on them, and now you can keep one at home, send one to your opponent as just, you know, whatever you want to do with them. Some courts are starting to really push electronic filing, and so everything I just said regarding that won't apply to you. Like, I know that in Nevada, Clark and Washoe County have electronic filing. None of the other counties do, so all of those counties are still mailing things. But if you're in Clark or Washoe, they force you to sign up into this online system, and you file it into that system, and it's just different. It's a whole different process because you don't go down to the courthouse and nothing gets stamped. It just gets processed through the electronic system. If it's rejected, they'll give you a reason explaining why, and you can fix it. So my next 2 videos, the next one will be on opposition, and the one after that will be on replies. So hopefully this trio of videos will teach at least some of the basics or the procedure behind the motion, opposition, and reply, which is pretty much the bread and butter of motion practice and of how to get issues brought to the court's attention. I'll talk about what happens after the court's fully briefed on my reply video. So just keep an eye out for that video. For now, I will see you guys next time.